edition of Lawfare Live from Greenbelt, Maryland Public Library. Uh, it is Roger Parloff and Anna Bauer, our intrepid U.S. District Court for the District of Maryland crew, looking here like they are being held hostage in. So if they start making secret signals with their hands, or you just interpret them as the real message they want the FBI they want the FBI to hear. Anna and Roger have just emerged from the hearing before Judge Sines. And I want to start with breaking news from Roger's feed, Twitter feed, which is that we now know how to pronounce the judge's name. So, Roger, what did you learn and how did you learn it?
I spoke to a clerk in the court, and she sounded authoritative, and she said it's pronounced C knees. And so I think that sounds like she must know what she's
So
doing.
you heard it here first, people. This is news you can only get on Lawfare Live. Everything you've heard everywhere else is wrong. The judge's name is Paula Sines, and just think your eyes and your knees. All right, we're done. All right, so we had, for those of you who were following along, Anna covered this on Blue Sky. Roger covered it on Twitter. Let's start, Anna, with just an overview of what happened. The judge walks in and seems to know exactly where she's going. Does that seem right to you?
So I got there right when the hearing started because of some transportation delays, and I had 5 minutes in which I was trying to I had an internet connection issue. So I'm going to let Roger start us off with the very beginning of the hearing because I was
otherwise occupied.
I was frantically trying to get my internet to reconnect after I had a debacle with it.
All right, so Roger, give us an overview. We'll get to the details in a minute. My impression: she walks in knowing where this hearing is going. What did you make of the overall direction of the thing?
I think that's right. She was much more calm than I expected. Very deliberative. Like Boasberg was calm also, but he was seething. You could tell. You could not tell that she was seething, although she probably was. She was much more controlled. And I had the impression that, it was pretty obvious she's already got an order 9/10 written that she's going to release this evening, ordering discovery. But she just controlled, asked the plaintiffs, you have a motion pending. Do you want to speak first? The plaintiff's lawyer, who was not Sandoval Motionberg, who is off this week, but Rina Gandhi from the same firm, and she actually only mentioned the request for discovery. She didn't even mention the request for a show cause order, which would commence contempt proceedings. And then the judge obviously thought, yes, that was the wavelength she was on, and then there was some, and then she turned to. Do you want to take it from here,
Yeah, look, she turned to Drew Ensign on this point. He attempted to make the argument that there's a pure question of law here. The government, in many of its filings, and its response to the plaintiff's motion, has suggested that there is this debate over what facilitate actually means, because that's the term that the judge ultimately amended her order, that the government has to facilitate the return or release from custody in El Salvador of Abrego Garcia. So Ensign raised this question of whether discovery is even needed because, they think that there's this question of law. There are questions about whether or not the judge has authority to, compel them to request from El Salvador, a foreign sovereign, that they release this guy. The judge, of course, responded that, but I haven't even gotten there. I haven't compelled you to request anything. We're just looking at what steps have you taken, and is that sufficient to show that you've complied with my order? Roger, am I missing anything there in terms of the general gist of Ensign's arguments?
No, I think that's right. I wasn't quite clear when she said we weren't there yet. I think we'll have to look at the transcript whether she said I haven't ordered them to release him. We aren't there yet. I don't know. Maybe you're right that it was I haven't even ordered you to request that they release.
I heard, so that's how I heard it. Again, we'll have to check the transcript, but I heard it as, her saying we're not there yet. The plaintiffs have construed this order in that way, but it's not that I have told you that you have to do this. And then at one point she even mentioned the fact that, and this has been because in the government's view, that all they have to really do is just say, oh, well, if he shows up at a port of entry, then we'll take him into U.S. custody. And today in a status update, they said, and if he does that, then, we'll remove him to a third country, or we will withhold his final order of removal, or we'll remove his final order of removal that prohibited him from being removed to El Salvador, and then re-deport him to El Salvador. But, I think that in the judge's view, that's not sufficient. And there's this debate about whether they have, showed sufficient evidence of complying. That all goes to the facilitate question. At one point she said, I'm not saying you've got to have planes on the ground, but I am saying I know that the government has done this in the past. This is not a problem that's uncommon in terms of getting people back who have been mistakenly or wrongly removed. So there was kind of this back and forth between the judge and between Ensign about not only, are there outstanding legal questions, but, it seems like this looming question that at some point the government is going to try to force her hand of answering the question of what exactly does facilitate mean. Again, Roger, correct me if you got if you heard something different, but I think the judge was saying, we're not at the point of me saying you have to ask this, but I think the Supreme Court was pretty clear in saying, there are some steps that you've got to take, and you've got to try to, and she read from the order several times that was issued by the Supreme Court. And so again, we're not quite at the stage yet where the judge is, as much as the government wants, ready to clarify what facilitate means, and she wants discovery because she thinks that the government rightly thinks that the government has not complied with her request for information about what it is that they've done, what potential steps they will do, and what his custodial status is.
She was clear that she doesn't need. She's rejecting the idea that facilitate only means removing domestic obstacles. She's clear on that. And so, she understands they're going to make that argument. She rejects it. She thinks that it's absolutely clear. And she kept asking, the questions I put to you were the questions the Supreme Court said you needed to try to answer, which were what steps have you taken? And they haven't answered that.
Right. And so their position is facilitate is constitutional only to the extent that it requires them to do nothing more than remove domestic barriers. Although they complicate their case because they then say, and if he shows up at a domestic port of entry, we'll deport him again. So that they say they've removed domestic barriers only then to reimpose them. But that seems to be their position. Her position is no, it clearly means more than that. And there's a lot of room between merely removing domestic barriers and anything that would come in the way of what the Supreme Court says, come anywhere near what the Supreme Court says, the limits of the district court's authority. And so she kind of instructs the plaintiffs, okay, keep your discovery within that space, and I will referee balls and strikes. Is that a fair summary of where she came down? And I'm just working off of the two of your reporting. So,
and just to add one thing to what you were saying about this removing domestic obstacles, she also brought up that one of the things Bukele said yesterday was, I can't smuggle him into your country. And she said, well, it doesn't sound like you're removing domestic obstacles, does it? So, you tell me what you've done and so on. But otherwise, what you said is right.
All right.
Yeah, I think that's right. And we did also get some more information from her about, we're still waiting for a written order. As Roger mentioned, it seems like this written order is probably more or less written, but she ultimately, where she came down on in terms of all, the government saying, we think that there's no need for discovery right now, not only because what we've submitted is sufficient in terms of these affidavits, but also because we think there are still outstanding questions of law. She said, no, I think we need to go for expedited discovery. She was very firm. It's going to happen over the next 2 weeks. We're going to follow the federal rules of civil procedure. There will be interrogatories. There will be depositions. There may be requests for production. And she gave a preview of the timeline that, again, we're waiting for confirmation of this in the written order. But it sounded like, from what I understand, she expects that at the very least, the people who will be deposed will be the people that the government has put forward in its daily the declarations they've put forward in their daily status reports. That includes people like ICE official Robert Cerna. It includes the acting general counsel at DHS, Joseph Mazzara. It includes
the State Department official,
a State Department
Kozak.
official, Evan Katz. Thank you, Ben. There may be one more that I'm forgetting, but at the very least, those individuals she wants deposed. That she expects that those depositions would be completed by April 23rd. She made it clear that throughout all of this, the government will have every opportunity to do objections and responses and, preserve anything that it may want in terms of any kind of objections or opposition that it has. But she is very firm that she wants it to keep going. She wants it to be speedy and efficient. She even said at one point, and correct me if I'm wrong, Roger, but I think she said at one point, even if the depositions need to take place at the courthouse and she can call balls and strikes, then she will.
Yeah.
And she wants by April 28th, I believe it was, that everything's going to be completed. The plaintiffs will file a supplemented filing or briefing on their motion. Then there will be a reply, and then they'll go from there. So that's the timeline that she set out today.
All right. So I want to ask you a question that's going to sound weird to you guys, but actually responds directly to things that were tweeted and blue skied in response to the specific news that she had ordered this 2-week expedited discovery. And people responded with sort of irritation and disappointment to that timeline. They want her to rule now. And my reaction was, as somebody who follows a lot of civil litigation. My God, 2 weeks of, that's a lot. That's a really fast, compressed discovery timeline. My assumption is that the plaintiffs were thrilled with this outcome. I noticed that they didn't object, but do we have any sense of whether, Abrego Garcia's lawyers here were irritated at the slow-moving pace of civil litigation and the court system, or were they, this was all they could hope for reasonably, and they were excited by it?
They seem to be happy with it, and like I said, the fact that they didn't even bring up contempt in their opening statement meant, I think, that they figured that we need to go step by step, and it is frustrating. And she said, there will be no vacation days. Every day is a business day. Every day that passes is another day of irreparable harm. She's tough, but she's understanding that the scrutiny, she's under very minute scrutiny, and she's going to take it step by step, get the facts, and then lower the boom.
I mean, also, look, she knows that eventually, like, whatever it is that she orders, if she finds that they are not in compliance, it's going to go up to SCOTUS. And we've seen in recent orders from SCOTUS, the way the facts are presented are just, for people who spend a lot of time in these hearings at the district court level, a lot of the facts, when it goes up to SCOTUS, are then ultimately portrayed in a light that don't seem to be totally accurate. And I think that the idea here is that, you move as fast as you can, and this is very fast for court speed. But you also move at a pace that's going to allow you to get the information that you need to build a record. I don't think that's not to say that Judge Zenas or Sini's, thank you, Roger, for
this is the kind of breaking news you only get at Lawfare. Is
right.
Adam Liptak telling you how to pronounce this judge's name?
This feels like the moment that we learned that Emile Bovee is Bovee and not Beauvais.
We might have broken that too.
Yeah, I think we broke that too. So this is why, Lawfare, breaking news about the pronunciation of people's names. But look, this isn't to say that Judge Sinis has an outcome in mind yet, but she certainly seems to be very concerned, and rightly so, that there is non-compliance and that multiple people are acting in bad faith. And I think that she wants to build a record and have an airtight order that she can write around that record if it is in the end the case that she finds there's non-compliance.
Right. So I think the core issue for everybody who's confused about the timeline here and why it feels slow, and both of you, I'd be curious if you disagree with any of this, but the core of the issue is the following. She knows that she issued an order to facilitate his release. She knows that she posed a certain set of questions about what's been done, about what steps are planned. She knows that he hasn't been released, and she knows that those questions haven't been answered. But she doesn't know whether they're for sure. I mean, you have an instinct that there have been no steps taken, but you actually don't know that for sure. And more than that, you can't prove it. All you can prove is that they've entered nothing in the record to show it. But there could be behind the scenes phone calls. There could be, quiet diplomacy being on. I don't believe that, but it's theoretically possible. And more important, you don't know if, assuming that nothing has happened, you don't know who's responsible for that. Is that President Trump, sending down through Stephen Miller, don't bring this guy back? Or is that people intuiting what they think he would want and maybe thinking, you can ask but wink, right? And so who's responsible? You can kind of intuit that there's contemptuous behavior going on, but if you want to hold somebody in contempt, you need to identify who specifically violated what court order and under what circumstance. And this is an attempt, particularly if you're going to hold them in contempt and then order some coercive remedy. You have to figure out exactly who did what to whom. And what she's saying to the plaintiffs here is, don't go crazy. Don't stomp on the president's constitutional authority to do foreign policy, but figure out the answer to this question and I'll back you and give you depositions. You got 2 weeks. Is that fair?
Yeah, and in fact, she gave them 4 depositions, but said they can apply for 2 more. So maybe that would be a way when there's more information, you could go up the line a little bit. She's going to give them up to 15 interrogatories, up to 15 document production requests. So maybe with that, she can begin to get an idea of if there was, let's keep an open mind, if there was defiance and contempt, who's responsible.
All right, so let's talk about the government's response. Most of the conversation seemed to have been with Drew Ensign. Is that
98%, I'd say.
Mm-hmm.
And his position, as I took it, seemed to be, number one, don't order discovery. Number two, if you do order discovery, let us appeal it first, stay it so that we can have an appeal over whether any discovery is appropriate. She rejects both of those and says, I'm going to issue an order tonight on, and number three, he seems to fight her on the premise that they haven't done anything. And his, at least as I read your guys' tweets, the evidence that they'd done anything was really limited to the text of the meeting in the Oval Office yesterday between President Trump and President Bukele. Is that correct?
That's what he was saying.
That and then also the Mazzaro declaration that they filed today, he also pointed to as well. Specifically, I believe it was paragraph 9 or paragraph 11, doesn't matter. The paragraph in which Mazzara says something to the effect of, and this was they keep dropping these little breadcrumbs of new information. Usually every day it's something that's both new, but also not somehow non-responsive to the judge's questions. But so the one that they dropped today was effectively the same Mazzara declaration that they submitted yesterday, but this one had a line that said, if he shows up at a port of entry, then we'll either redeport him to a third country or to El Salvador again after his withholding of removal is removed, which again, look, I'm not an immigration law expert other than paying attention to this case and some other cases we're following, but I don't...
Which makes you more of one than most people, actually.
But I don't think that it is... They're basically using this same argument that is a novel argument, as I understand it, that all of a sudden, if you are someone who is alleged to be a part of MS-13, which they've classified as a terrorist organization, then that somehow means that you're not able to have a withholding of removal, which is not something that, as far as I'm aware, is consistent with current law.
Okay, but I'm hung up on...
Roger has something to add on that point.
Yeah, please.
Well, I don't know if that's a law. It could be the law today, but it's not retroactive. You can't, there's a final order that he has withholding of removal. So if you want to go back to him and say, and argue to some judge, Well, Rubio 2 months ago said that this gang is a terrorist group, so now you need to lift that. It doesn't sound like they plan to go through any legal process. They just
Right,
plan
yeah.
to just announce, no, it's gone and he's
Yes,
gone.
and that's what I mean, but
I'm hung up on an antecedent question, though.
yeah.
All right. So the Supreme Court says he's got to be put in the same position that he was before he was arrested, right? That you've got to, whatever facilitate his release means this was wrong, and you've got to endeavor to put him in the same position. And the government comes into court today and they make two arguments. One is that the president in the Oval Office didn't ask for his return, and in fact justified or sat there while the president of El Salvador said he wouldn't smuggle him in, didn't request his return. So he's not, but secondly, that if he showed up, they'd deport him again, which seems like two arguments that neither of them amount to we're working to put him in the same position as he was. And I'm curious for either of your sense of why they think that's an argument that will appeal to her, to the Fourth Circuit, or to 9 justices who said you gotta restore the status quo, or at least try to.
I mean, if he's right on the law, if there is, if you came back and you had process and you went before a judge, I don't know if it would be an immigration judge or a federal Article 3 judge, or first the immigration judge and then a federal district judge, but and you could convince him, okay, the real law is now he's a terrorist, now he's not entitled to this, we'd like you to strip it of it. I mean, all of that would be consistent with the court's ruling as I read it. It would be going through a process they could have gone through and didn't. But what they can't do is just, bring him to the border and then, say, poof, the withholding is gone, send him back. That would not be following the request. That's how I read it.
So I also will say, Ben, too, it sounded to me like I think that what the government has stressed is not so much the fact of Trump not asking for return, although I think the plaintiffs have pointed out that there's no evidence of an ask occurring, but they've pointed to instead in that transcript the statement of Bukele, which is that, how can I smuggle someone in? And then they pointed to Bondi's statements as well.
Right, but that's, I mean, that seems to me to be I watched that thing live, as I think did you guys. Like, this did not strike me as the U.S. attempting to facilitate his freedom and return.
Right.
It struck me as the president asking his aides, his attorney general and his creepy Rasputin figure, to sneeringly justify his declination to ask for the guy's release, which he did not do. And then to punt the matter to him, who Bukele then pretends he doesn't understand the question. Bukele, who speaks perfect English, by the way, suddenly can't understand he's being asked to smuggle this guy into the United States, a terrorist, into the United States. And so if I were the district judge, or for that matter, Clarence Thomas or Sam Alito, and I had ordered them to facilitate his release and return, I would see that Oval Office meeting as them doing the opposite of facilitating his release and return.
Well, look, no, but look, anyone with eyes and ears who watched that understands what is happening. But I think this goes to your earlier point, because, right, you've got in that meeting, you've got on the one hand, Trump and Pam Bondi saying that, oh, the U.S. doesn't have the power to interfere with a domestic sovereign, who has this guy in custody. We don't have the power to return him. And then you've got, the president of El Salvador saying, but I don't have the power to return him. And so it's a hot potato, right? Of like,
Right.
oh, we don't have the power. We
Monty.
don't have the power. And anyone who's watching this knows what is happening. And the issue, though, is that what you said earlier, Ben, that like, I think actually if you're Samuel Alito or if you're Clarence Thomas, you're watching that thinking, oh, that's, that's your answer. They couldn't facilitate the return because there are ways in a written order you can cast a certain light on those interactions and of these facts to at least have some kind of plausible, if just blatantly wrong perception or way of construing everything that's happened. And so I think that goes back to your earlier point of that's why it's important to establish a more clear record of what has been done, because they have not said, other than that Oval Office meeting, what have they done? And so I think that's what Judge Sines is trying to do here.
And I think they want to get the contract. And if they refuse to produce the contract, I mean, there's already a lot on the record about the contract. Bukele has mentioned that they're there for a year, renewable. The AP says they've seen the contract, the $6 million for a year. They continue to send people down there. Kristi Noem visits. There's clearly, and if they say no, it's a state secret, at some point you don't have to forever litigate that. You can say, oh, I see, they're acting in bad faith. This is idiocy. And they're also going to probably invoke privileges. And that's why she said she's giving them the 4 people who have already submitted affidavits, because she's going to say, how can it be privileged when you already produced them? They already gave a partial statement. And so she's building a record of this. The real problem, of course, I say, she's going to eventually lower the boom. We don't know if there is a boom when the contemnors are high executive officials doing what the president wants, and you have a Congress that won't do anything. Maybe there is no remedy here. That's the scary thing.
Well, so I think.
And by the way, I will say one other thing too. All of these people who have provided statements, or at least not Robert Cerna maybe, but the other ones, to some extent, they're all not really saying they have personal knowledge. Mm-hmm. They're all kind of saying it was relayed to me, or as I understand it. So I think we're going to get this chain where, they might come in for depositions. There might be claims of privilege for at least some of them. The acting general counsel, for example, Ensign, referred to maybe raising some privilege claims there. But even if you get through all of that, it is probably going to take us into a second stage potentially of discovery, in which you then got to go after the people who actually have personal knowledge, because they've put forward people who seem to not really know anything.
All right, so 3 questions to wrap up. The first is, at what point does this process of investigation / discovery itself become a sufficient pain in the ass that the administration decides, hey, better just to have this guy sent back? Or do they love the pain because it puts them in confrontation with their favorite thing in the world, which is an Obama-appointed district court judge who they can threaten and, have people introduce impeachment resolutions against? Is this the kind of thing that the process is itself the punishment, or is this the kind of thing that they love the process?
This gets a little beyond our bailiwick and into politics. And my sense is that they're very, very happy with the politics of this, and that's why they're putting it on TV. And so I don't think it's painful to them, and I do think they will. This 14-day, timeline. I think they'll do everything to derail that, and you know. Trump's lawyers are very good at stalling. That's why he's president. And so it's going to be very hard to keep this on a 14-day track.
I'm going to be a little bit more blunt than Roger and say they absolutely love this. Stephen Miller is loving it. He's going on TV every day, completely misrepresenting Supreme Court opinions that are quite clear. And seems to be having the time of his life doing it. And so I don't think that this is seen as a problem. I think that it is seen as part of an effort to, look, and this is speculation, but I think that it may be seen as an effort to suggest that district court judges and district court orders need not be followed.
All right, next question. Is the government, do you think, I took it that they're going to take an emergency appeal from whatever order she puts it. She's going to put out an order tonight that says facilitate means more than remove domestic barriers. And by the way, you can throw him out as soon as he shows up again. And I think they're going to try to take an emergency appeal of that. Do you guys agree? And do you think that if they do, that appeal has any legs, or will they not be able to get a stay on this?
I thought, initially he certainly was going in that direction. He said he wanted her to stay while they seek appeal. Then he said some things that sounded like, she was saying, do you have a problem with this? And she said, well, we'll work expeditiously. I assume, like you, that they will try to take an appeal. Now, ordinarily, if this were anybody else, I don't think, you can't appeal a discovery order, but he has appealed temporary restraining orders galore with success, both at least having his issues heard on the merits at the Court of Appeals level, and then even at the Supreme Court level. So it seems like if he casts this as an Article 2, emergency, they're intruding on our Article 2 rights. It may go up. What do you think?
Yeah, Roger mentioned you can't appeal a discovery order, but I think and I'm interested to see how this written order is crafted, because the judge did say that she would respond to some of the arguments that Ensign has made. And I think that insofar as the government can construe that as some kind of order on a more substantive question than just a discovery order, then that's what they'll do and try to, appeal. They've been successful in getting things that would not normally be appealable appealed. So we'll see.
Yeah, I think they are going to appeal this, but I think it's going to backfire on them. And here's why. Because as long as they just have this bare bones Supreme Court opinion, they can interpret it in this extravagant way and wax indignant from the Oval Office about how the Supreme Court sided with them 9-0, and this district judge is, boldly interfering with U.S. foreign policy. The moment you ask the Supreme Court whether that's what they meant, which is what this argument over the word facilitate says, they're going to say at some level, no, that's not what we meant. We meant that there's some reasonable inquiry into what you're doing that she's allowed to do. She's not allowed to, take over the State Department. And so they're going to lose their whole rhetorical style. Their whole rhetorical energy comes from this lie that has its origins in the thinness and threadbare quality of the Supreme Court opinion. And by appealing this, they're going to actually deprive themselves of that, at least at the Fourth Circuit level. That's my guess. All right, last question. Does, this case has been relentlessly in the news for the last, several weeks. One thing about a discovery period is it tends to be pretty invisible. And if things go as she intends, you're going to have 2 weeks where this case is just going to vanish because you're going to have closed depositions. There'll be some kind of a protective order probably entered, as you usually do for discovery. And so how long do you expect? Roger said, you said before that you didn't think this would really be containable to 2 weeks. Anna said you're going to have to follow the chain and you may need more than 4 or 6 depositions. So how long are we going to spend on this discovery question, which will be mostly invisible to the public?
Well, like like Anna said, the goal is to have it completed and have this motion, which he delicately, euphemistically calls the motion. Everyone knows it's a contempt motion, coming up the 28th, and then they would respond the 30th, and then she would set a hearing. But one thing that we don't know, and maybe we'll find it out tonight when the order comes out, if it hasn't already, is whether the daily useless status reports continue. And the administration seems to use them as, almost a campaign sort of statement rather than a legal statement. I don't know if those continue, but no, I think you're right. There will be sort of a blackout on the useful stuff for a little while.
One thing I will say, though, is that not in a court of law and in the context of this case. I mean, there are some things going on with, Senator Chris Van Hollen, I believe, has been suggesting that he might go to El Salvador. He's been trying to, get a meeting with Bukele. Like there's some things that may happen because all the while, Abrego Garcia is going to be stuck in the gulag in El Salvador while this discovery proceeding is playing out, which is why I think people are very understandably confused and upset about the length of this discovery period, even if it is very quick for the pace of the courts. But there may very well be things, Ben, that we learn through public reporting. It may be possible that the AP, who has obtained these memos and some of these contracts, could publish them. I don't know if that's possible based on whatever deal or arrangement they have with their sources, that kind of thing. There are things that might prevent them from doing so, but there could be public reporting information that we learn in the interim period that is something to watch for.
We are going to leave it there. Greenbelt Bureau, Roger Parloff and Anna Bauer, thanks for joining us today. Thanks for your excellent platform independent live coverage. And folks, I would be remiss if I did not point out to you that right now a generous donor has pledged $15,000 as a match against any contributions made to support the work that Anna and Roger are doing. So if you find this stuff valuable, and I know you do, go to Lawfare's Give Butter support page, and let me give you that that URL. It is givebutter.com/lawfare, and make a contribution. It'll be worth twice what you think it's worth. Whatever what you pledge. That is givebutter.com/lawfare-institute. So thank you so much, and we will see you next time.